Some of you start classes next week, don't you? No. Because the JD classes start next week, and we're up in the fourth floor. Are all your classes here? Because I used to have them down at Dundas.
Fewer there, some are here.
Sorry?
Some are there, some are here, depending on what
I didn't know more people than this.
Oh, really?
Yeah.
Do you get food down there?
Yes.
Yes.
Sorry?
You must be hungry.
No, just because there was a real, it bothered a lot of people when they moved the courses up here. Because they said we pay for everything. Some I think wanted a discount.
For me, it's much more easier to have it downtown instead of here.
I think for a lot of people, it would be.
It's more
Yeah.
accessible.
So, what are your perspectives on the two articling groups? You know, that there's the L something something, LPP, and then you can article with a firm. Do you have perspectives on that?
I think that it's general preference to be an article position, and if you can, personally, to do that would be.
Okay.
Some people say LPP, the law practice program, is not good. Also, the Canadian law firm employer usually don't consider LPP as good as articling program, which makes me a little bit nervous and angry.
Why angry?
I'm just kidding, just because I mean, I don't understand, because LPP is LPP in my understanding. It also seems good.
Yeah.
But a lot of people say in their action plan B, if they are not able to find the article, maybe they're going to go there, LPP, yeah, something like that. I'm also thinking like that way as well.
Is it hard still finding articling positions?
I think, yeah, for international students, yes, it is. It is.
Okay.
It's really hard and
How do you find it
competitive.
hard?
Yeah. I think it seems very competitive. So many competition in comparison with my home country,
Where are you from?
Mongolia.
Okay.
I can find a job easily. Nice. Yes, oh my God, everything is.
Here, to put it in sort of international perspective, I think the figure from the UK is about 14% of law graduates actually work in law.
14%.
Yeah,
1/4.
1/4.
Oh.
Whereas in Canada, it's about 75% of law graduates get an articling position. So here would be euphoria for an English law student. So that doesn't take away from the competition. It's more to me at least, it seems very competitive, no matter what country you're in, generally speaking.
But I mean, with JET students, maybe probably it's more easier than international students, in my understanding so far.
Not necessarily, I would say. So let's take Osgood as an example. Osgood takes double the number that any other law school takes. So they have 300 students
For JD.
for JD each year. So if you just look at that cohort, that's a lot of competition from within one school. But also, how many of those 300 get an articling position with one of the big firms that everybody wants to article with? Will be the question. But I think even JD students have a tough time. I think my perspective has been for you guys, especially if you practice in your home jurisdiction, there's been, I see more people being able to get positions drawing from that, drawing from past experience. But it also depends on what country you're from.
Exactly.
Sometimes, like if you're from Russia, let's say, and you work with an oil and gas firm, then there will be some sort of natural overlap. So there's always, you look at what you can market. I think it's more relaxed doing your program. The JD programs, I remember my first year in the JD, we all had to do legal research and writing. And they make you do the paper research method, so you know in case your computer blows up, I guess. And somebody ripped the pages out that we all needed. And it was just sort of this ridiculous competition element. Like it depends on each group, but the JD course can be very competitive. What was it? I did my first 2 degrees at U of T. And the joke about U of T students was, how many U of T students does it take to screw in a light bulb? And the answer was 10. 1 to do it and 9 to worry about whether or not it was done correctly. And I think you can see that kind of in law school. The anxiety just gets that much higher. I don't know if you've taken JD courses, but you might be able to see it in that. That's why I think here you're a bit more relaxed in terms of the learning environment. It's not as stressful as the JD. Because basically with the JD, your first year marks determine your future. Because if you're applying in what, July? Well, you probably apply, there is something called summary, which some of you, the big firms, might push you into. Summary is the equivalent of working between your second and third year of law school. And then usually if you don't burn the firm down, you're invited back for articling. So those applications are based on your first year marks. And those are the big firms that go for those. I know a lot of people want to work at the big firms, and I'm not sure, I think you really have to look at what you're looking for. My brother works at a big firm. I did not. I articled at a boutique firm. I got to do whatever I wanted. It was ridiculous. What you might know is I got all sorts of exposure to clients. I did client development. I was in court a lot. I did a trial. And I didn't expect we were going to do a trial. The judge just decided, let's do a trial. And it was just like the rules of evidence. It was atrocious. And then I got to do stuff going up to the Supreme Court, Court of Appeal, you know, and I mentioned this not for anything about me, it's more, if you're at a big firm, you're guaranteed you're going to do a lot of research. You're probably not going to see a client.
True.
And if you look at coming out of articling, you want marketable skills. I'm not sure which one works best. You know, if, in order to work in a big firm, usually you have to article at a big firm. So there's that. But I don't think that the big firms are the be-all and end-all. But I know that some of my former students are keen on them. And I know a couple of people I taught, they articled at McCarthy's and were hired on. And McCarthy's is like the biggest firm. So, and they did the program here, that you're in. So there's just a range of things, but I think first of all, you have to look at what you want. And saying a job isn't good enough. Everybody wants a job, but think about sometimes what would work well for you. So going to your point, you know, the big firms, I think people have a tougher time with, for whatever reason. I know, like, you can speak to this, Canadians that go to the UK to do their law degree don't bother applying to a big firm.
Mm-hmm.
Because they, for whatever reason, they look at it as a Canadian degree is superior and you just couldn't get in here, which I don't think is necessarily the case.
Actually, you know, when I went to like Leicester, for instance, if anything, I'd say 90% of my peers were all Canadian, and they all came from like various institutions,
Yeah, well,
University of Toronto, UBC.
Leicester in the UK is well known for having like 200 Canadians doing the law degree.
Exactly.
Like Leicester is basically, the economy is driven by Canadian.
The Canadian country. And
Because they do the medical degree as well.
exactly. But I even had a friend from there who actually went to York University, and he did exceptionally well. He graduated with a 2.8 GPA, scored above a 167 on the LSAT. He didn't get accepted by Allstate, right? Back in
Yeah, but he would have been accepted elsewhere.
and that was the issue. He was applied towards like mostly Ontario region schools.
Yeah.
And then eventually he decided to go to Leicester. So it's almost circumstances, but then you have to deal with that. Various forms of discrimination when you come back, but it's not determinative. I know a lot of things.
No, but I think a lot of anxiety comes from when people are looking at only the big firms.
Exactly.
And I think it's worth keeping in mind that it's not, look at the experience you get, would be the way I'd look at it.
Just to add to that, I have two friends, so one who actually went to Western and works with Denton right now, and the other one who works for like a mid-sized firm in Vancouver. And just like how you mentioned earlier, too, the one who works at Denton pretty much has no contact with clients because they're like, you know, very lucrative deals as well, right? And then at the same time, mostly just does legal research in contrast to like the mid-sized or boutique firm where you're pretty much going to court every single day and you're actually having a client interview.
Yeah. And look, so I'm not telling you which one is better as much as look at what fits best for you as you're looking through things. And I think Allstate here has a good level of support. I know there are varying opinions depending on who you talk to, but there is help that way. So we're wrapping up the course now. We have 2 weeks left. So I told you that we wouldn't do remedies, which is basically damages, but we spend the extra time on the overlap between contract and court. So we've touched on this a little bit already, and over the next few classes we'll draw that out. That is that many scenarios there's an overlap between whether or not there could be a claim in contract and a claim in court. And if you recall the exclusion clause topic, exclusion limitation clause topic, that's an example where we have this overlap that maybe there's been a breach of the contract, or if not, there could be carelessness in how work was done, which would be a tort. And the difficulty is knowing which one to pursue. So I'll sort of start with the end. You can pursue both concurrently. You can sue in contract and tort concurrently. And that comes from a Supreme Court decision from 1993 called B. Checo versus B.C. Harper. But you cannot recover in both tort and contract level. So this is a principle you probably found in your foundations class. There's no double recovery. So you'd have to choose. And based on what you have seen in contract and tort, which do you think would be a better one to pursue? Tort.
Is it harder to prove?
Sorry?
Isn't it harder to prove?
See, clearly it depends on the scenario, but I would say generally speaking, in contracts, damages are, there's usually a provision that talks about damages being capped. So if you think about the Finney Lock Seeds case, and that's the one where the client suffered a loss of about £60,000, this was from the UK, but the contract said if the seeds are defective, we'll reimburse you the cost of the seeds. That was about £200. So there you would clearly want to, if you can't get avoid the contract provision, which they did in Finney Lock Seeds. Otherwise, you'd want to sue in tort in some way, because that allows for your recovery to be higher. If you have the option. So if we think about a law firm or an accounting firm, they will usually have a provision that limits or caps their liability. That's why, as we talked about before, they're a limited liability practice, LLP. Usually that's about $1 million. But if your losses exceed that, then you'd want to, tort would be the way to go through that, more likely. Now, I think Ebra, I think it was said, isn't it harder through tort? And I don't think one is easier than the other, I would say. I think what you make the assessment on is really, what can you establish? How strong are your arguments? So, in looking at that, you'll have a comparison of thresholds. In order to establish a breach of contract that allows you to terminate and sue for what's called your expectation damages, what you expected to get if the contract had been performed correctly. What kind of evidence you have to that? What kinds of arguments can you put forward? And I would keep in mind a case like Hong Kong Furs. We talked about that in terms of that threshold of what's the difference between a breach of a condition and breach of a warranty. Breach of a condition allows you to sue for termination. It's a repudiatory breach. Whereas a breach of warranty means the contract is preserved and you sue for damages for what was lost. And that may not be as much depending on the circumstances. So you have to look at that aspect. And then with tort, I'd say with negligence, for example, you have more leeway in one sense. Because you don't have to prove intent or anything like that. You can even say, well, here's the bad outcome. You were careless, and here's my evidence that you were careless. We have this bad outcome. But as you might recall from the past couple of weeks, establishing a negligence claim can be challenging. So what we're looking at here is weighing up how do you make that determination? What are the factors that go into making that determination? So today we'll look at tort, misrepresentation. What's the other day we meet? It's Wednesdays. On Wednesday, we'll look at contract. And then next week, we'll further go through things. I chose the topic of misrepresentation or interference with economic business interests because I think this is most often where we have the overlap. And usually the overlap arises in a situation of providing professional advice. I would say that's kind of the classic scenario because you obviously have a contract to provide services. But the question is whether or not the service provider exercised those obligations with due care. Were they negligent in some way? So, misrepresentation looks at was there a statement provided that misled the other party? I'm trying to think of, to give you a definition that covers both contract and tort. There's something very specific in contract that we'll look at next time, but in tort it's a bit more open-ended. So generally speaking, what we have with negligent misrepresentation is the additional hurdle of pure economic loss. And we looked at this concept when we looked at the Mr. Submarine Foods case. That was the Maple Leaf Foods case. And again, just for clarity, pure economic loss is where it's only money that was lost. So in these instances of contract and tort overlap, you're looking at services were provided or advice was given in a way that the plaintiff is alleging is falling below a standard, whether that's a tort or duty standard, and it's led to purely money losses. And as I said before, just to refresh your memory, I'd use the story of Beresford Road, where you have this pocket in the back of your road that historically was put there so clients could sneak up and give you the money and you didn't have to look like you were accepting money for your services. And I use that as an example of, if you did literature or history, you'll see a theme through time that money has been seen as a kind of immoral in some ways, dirty. And this is what we're looking at here, where it's sort of, we've gotten over that hurdle. But, so I give you the Ultramaras, the New York case, which talks about one concept of independent liability. But generally speaking, courts didn't want to provide remedies where it was just money that was lost. It was just seen as not worth the court's time. I'm not 100% sure why, but I think there was sort of this idea of a morality overlapping. The other difficulty which has continued is the idea of indeterminate liability. If we allow somebody to recover only money losses, won't that open up a floodgate for others to sue for their purely economic losses? So the courts are attuned in this area that we're looking at now to more precisely defining the class of people. What I mean by that is not a class system, but that if we think about it, an accounting firm will be responsible to its clients. But what about clients of those clients? And so on and so forth. So you can get to a point, and I think the Imperial Tobacco case that I'd asked you to read shows this. You can get to a point where there's no real limit to who could be a potential plaintiff. And that's the definition of indeterminate liability. So in pure economic loss, there's a concern about this point. So under the heading negligent misrepresentation causing pure economic loss, I've given you a few reasons why recovery has been problematic. Number one, I think you've probably encountered in your lives already. At social gatherings, as soon as people find out you're in law, you become a very popular person for those seeking free legal advice. And the problem, as you probably know at this point, is if you give advice to someone and they rely on it, they may come back and sue you. Whether it's right or wrong of them to do so is almost irrelevant. You cannot stop someone from suing you. You can only limit the success of any suit. So you're circumspect when you give advice to people. And you always say things like, I think you should see a lawyer. You know, things like that. Second. So the other three, I think I've touched on a bit already. The Canberra and Crane case is a representation of the traditional response that there's no liability for negligent misrepresentation unless it's a fiduciary relationship or the misrepresentation is fraudulent. What's a fiduciary relationship? Have you come across that?
Operational responsibility.
Like a bank has a fiduciary duty toward their customer, or like somebody who has like superior power somehow.
Yeah.
It's a relationship of trust.
Yeah.
And the principal has to act in the best interest of the
Beneficiary.
Of the beneficiary.
So a fiduciary relationship is one of the highest forms of obligation in law. And it says basically the fiduciary has to act to the benefit of the beneficiary and not for his or her own benefit. The classic case for this is Dairy versus Peak. So the idea is that if you are in a fiduciary relationship, you have added obligations that go beyond contract or tort. These would be equitable obligations, which we don't cover here. But it's worth explaining that that's sort of the highest level of obligation. The other traditional, part of the traditional response is misrepresentation that was fraudulent. What is a fraudulent misrepresentation?
He knows he needs a statement and he knows it's not true.
Yeah, so you say to someone, I'm selling you this car, it's never been in an accident, and you know it has been. You are intentionally deceiving the other party. But the problem with that, as I've noted to you before, is you have to prove that that other party knew and intended to deceive you. And unless you have an email or something like that that says, I'm going to fraudulently misrepresent myself to this person, it's hard to prove. So that's why we have this other aspect of misrepresentation called negligent misrepresentation, where somebody was careless. And that means you don't have to prove intention. There's a third category of misrepresentation called innocent. Innocent misrepresentation means you were mistaken in some way. I thought this car, I don't know car. I thought this car had six cylinders, but it only has 4. Somehow I just didn't realize that. So that's still a misrepresentation, but there's no intent or carelessness behind it. We treat innocent and negligent kind of similarly, it seems, because both are misrepresentations. So that's all to kind of set up the landmark case of Headley Burn.
You said negligent and mistaken?
No, negligent and innocent.
Innocent, when you have innocent situation that are reliable or not?
Yeah. Yeah, because you've still you still misled the other party. So if all you have to prove is that the other party was careless or for whatever reason. So if I'm selling you my car, I think it's a 6-cylinder, but it's actually 4, and that's important for you in the bargain. I could have checked the owner's manual
But what's
to
the
verify.
What's the difference between?
The difference comes down, it's sort of historical. Fraudulent was the only thing you could claim for. Then 64 came along, you could establish negligent. Then the question was, well, what if I just made a mistake? And I think it depends on the facts, but generally speaking, I think it would be difficult to get out of a claim of innocent misrepresentation if it overlaps with negligence in some way, like in my example of the car. If I could have checked.
So it will usually overlap?
Yeah. So Headley Burn changes everything in 64. And I think the facts are ones that you have to keep in mind. Put in a very simple way, you can't say something like, the House of Lords in Headley Burn found that the defendant was negligent for negligent misrepresentation. That's not accurate. Because in fact, this is a case of contract and tort overlapping where the defendant had an exclusion clause that excluded liability for tort. And that was found to be effective. So what Headley Burn says is that it removes the restrictions on liability for careless information and advice causing economic loss. You can recover, and it sets out a 3-part test. But the facts of the case were not such that the plaintiff won on negligent misrepresentation because of the power of the exclusion clause. So simply put, this was a situation where an advertising agency was looking to extend credit to a client. And they asked the client's bank, are these people reliable? Basically. And the bank said, sure. And it turned out they were unreliable. And the advertising firm lost under £20,000, which in 1960s England is a fair bit. So they sue, saying that the bank was negligent in providing the advice they did. And the court finds they were negligent and explains that there's a three-part test, that there's a special relationship, that there's foreseeable and detrimental reliance, and that there was reasonable reliance. So these three elements are made out, but there is no liability because at the end of the letter that the bank provided, they said, we are not responsible for any losses that ensue. It was better worded than that, but just for simplicity. It was an exclusion clause. So Hedley-Berg gives us this three-part test. There's a special relationship. Usually that comes up with a contract. If you are providing services to a client, you would have a contract for the provision of professional services. Second part, that there be foreseeable and detrimental reliance. Well, it would probably be accepted that if somebody pays for your advice, they're going to rely on it. They're going to take actions that flow from that advice. And it would be reasonable for them to do that because you hold yourself out as whatever the professional service is, law, accounting. So this is, I think, not only a good example of, this topic generally is a good example of contract and tort overlapping, but it's also sort of very close to home because it involves everybody's practice. You provide professional services. This is a claim that a client would try, a disgruntled client would likely try to bring against you. Yes.
And the problem with this case is that because in case of
Sorry.
I have a little problem with this case
Yeah.
is that in face of the disclaimer clause, whether the reliance is still reasonable, it's just artificial to break the decision to choose that. You can just collapse into one step, say that reasonably the reliance is not reasonable because of the disclaimer.
I would separate them because I don't think, I think if you put them together, you get into a sort of a messy overlap that doesn't help.
But from a reasonable perspective, if there is a disclaimer, when someone gives you some information and give you a disclaimer, then
Yeah.
you say...
But we've seen where exclusion clauses are provided and they're found not to be enforceable. Does that mean that those people didn't rely on them or they were reasonable not to rely on them? This is what I'm saying, that you're conflating two different questions. So I think the better route is following what we have so far in Hedley-Byrne. Was the reliance reasonable? So if you're at a party and you ask somebody, should I invest in this stock? And they say yes, there'd be a question of reasonableness in terms of relying on that advice. But the exclusion clause comes aside from that because it basically says, I may have messed up, but it's still not my fault. I'm not responsible, is a better way to put it. Yeah.
Would the reasonableness assessment,
Sorry.
would the reasonable assessment kind of hinge on whether or not somebody had the opportunity to, for example, to use your car, your 4-cylinder versus 6-cylinder illustration, and assume that the person could inspect?
Yep.
Is that...
That could go into it.
Okay. And would one then raise a potential apportionment, maybe not in that example, but perhaps if it's a tort claim, sorry, a contributory negligence
Yeah.
apportionment?
Yeah. Possibly. Generally, you don't see that in negligent misrepresentation because reasonable reliance is either or.
Okay. I'm thinking of auditors, for example, issuing financial statements.
Well, we have some cases
Yeah.
that we'll look at on that.
And a third party ought either not to have reasonably relied on, or done their own kind of assessment of value.
Yeah, so we saw that with Caparo, for example. So there, Caparo should have obtained its own independent advice for the purpose of buying the company. So I think underlying what you're asking is the principle that the court will see in the cases is putting through that you can only sue somebody within the confines of the purpose for which the advice was given, not beyond that. And in my opinion, when we get to Deloitte and Touche, I think that line gets blurred. And I'll talk about why.
Just to go back to the motor vehicle or your 2018 exam question, that was involved a hotel and
Did it?
pardon me,
Did it? I don't remember, yes.
Well, anyway, it doesn't matter. It was effectively a representation about the fixtures that were installed in the hotel. There's presumably a distinction between somebody saying something without the other party having had the opportunity to examine. So in the case of your motor vehicle, you might be on the telephone, or whatever, there's an exchange of emails. Would reasonable reliance kind of negate, if somebody has the opportunity to inspect?
It can negate it.
Okay. If in other words, if they don't exercise that right for whatever reason?
It can.
Okay.
So, as you know, in the common law system, we can say in the abstract that can hurt or be fatal to a claim, but it depends on the facts. But the argument may be available. So in any exam question, which was what you couched it in, there would be competing arguments on points regarding if you take the Headley-Burn three-part test on each of those. One party would say it was reasonable, the other party would say it wasn't reasonable. What are the arguments for them? So we have the Hercules management case, which brings us into Canada. And I'm going to focus not on the facts, but on the reasoning of the court. So they find no duty of care for policy reasons, the policy reasons being indeterminate liability. And the test they devise is, if you recall, I said a lot of the tests in private law in Canada are variations of the ANDS test. That's what we have here. So I think I've given you a summary of this case. And you have two stages, the reasonable foreseeability and then public policy. But at reasonable foreseeability, you have two subpoints. 1B being whether it was reasonable for the individual to rely on that advice. So here we see the Supreme Court of Canada adapting the Headley-Burn test to the ANDS framework in Canada. And this is a fairly lengthy test, if you think about it. Because this isn't just 1A and B and then 2A and B. Because at the stage of 1B, we also have 5 considerations that I've noted for you in the summary of the case. So these considerations are, if we take the first one, the defendant had a direct or indirect financial interest in the transaction in respect of which the representation was made. So, did we have that element here, would be your question. Then the second one, the defendant was a professional or someone who possessed of the skill, judgment, or knowledge. And here we clearly see the heavy burn concept coming through. So this isn't really a surprise. 3, the advice or information was provided in the course of the defendant's business. What does that mean? Well, if it was on a social occasion, maybe the reasonableness of the reliance, for example, would not have been so reasonable. And so on. So here we, as I said, we have 1 and 2, 1A, 1B, 2A, 2B. But within 1A, the reliance being reasonable, we have 5, what Kaltuzin called 5 general indicia of reasonable reliance. 5 things that we would look for. And I've outlined them for you in the summary. So the reason I don't go through the facts is because it's the reasoning that's more important for the discussion that we then have with the next couple of cases. I asked you to read Hill and Hamilton Wentworth because I think, I've said this before and it's worth repeating, sometimes reading some, especially Supreme Court decisions, is a very efficient use of time. Reading through portions, and I've marked off the portions for you in the notes. Reading portions tells you what the court's reasoning is. It's like an explanation written down. So I think Hill and Hamilton Wentworth provides that. But it's not within the negligent misrepresentation scenario. This is a case we looked at before. It said basically police can be sued for negligent policing. So the case we'll look at first is Imperial Tobacco, which Caroline is an expert on because of her illness. So why don't you tell us what happened?
These are appeal about 2 cases. One is cost recovery case that the government, the provincial government of the state, suing the tobacco company.
For what?
To recover the healthcare costs of tobacco-related units.
Right.
And the second case is the Knight case, class action, that Mr. Knight, sued the tobacco companies in order to get damages and punitive damages because he was on behalf of the consumers of mild and light cigarettes.
Right. So what are, also called low tar cigarettes. So that's sort of the background. What is it that we're looking at specifically here in terms of the facts with negligent misrepresentation? So I've used, should I use that here? Yeah, so within that litigation, the tobacco companies then sue the federal government.
Yeah, that's true. they claimed third-party notice.
Yeah.
So the federal government can.
So I've used this term before. If you look at civil procedure, which is very useful, there's this motion called a third-party motion. You bring a third party to the litigation and drag them into your litigation. One party does this because that party is saying, well, they're integral to this. I'm only being sued because of this third party. So the tobacco companies say, Canada's at fault. Why? Because tobacco is a federally regulated item, and the federal government makes pronouncements, has made pronouncements on tobacco.
And the federal government said that they should, if they continue smoking, they should change for their mild cigarette.
Yeah.
Yeah.
So within this context, the insinuation from the tobacco companies is, you, Canada, said smokers should move away from the, I don't know what you call them, regular cigarettes, to mild or light or low tar cigarettes. Lower nicotine levels and presumably less health risk. So the tobacco companies are saying, we only did this because of you. We're being sued now because of you for our lower content nicotine products. So the Supreme Court says there are two issues here. To whom did the government owe a duty of care? One group is the consumers. Second is the tobacco companies. Was there a duty owed to the consumers? Why?
Remote.
Sorry?
Remoteness, it's for remote.
Yeah.
It's not possible.
I think also there is a concern about indeterminate liability. And we'll see this play out with the policy reasoning of the Supreme Court regarding the tobacco companies. So to give sort of the end conclusion, and then we'll work through that, the Supreme Court says there's no duty of care owed to consumers, but there is a prima facie duty of care owed by the federal government of Canada to the tobacco companies, which then fails at the policy stage due to indeterminate liability. So if you think about the Hercules test, that public policy aspect is there. So let's look at the duty owed to the manufacturers. Why? So if we look at the duty question in two stages, what is a prima facie duty of care versus the policy considerations? Because the Supreme Court says there's a prima facie duty of care. Yeah. It can be rebutted. So the Supreme Court is saying at that first stage of analysis, we find that there is a duty of care. Reasonably foreseeable, foreseeability, the reliance was reasonable. But at the second stage of analysis, they say there is no duty of care because of the public policy reasons of indeterminate liability. So when you hear this phrase, a prima facie duty of care, as we're going through the cases, it means that the tobacco companies here were successful at stage 1, but failed at stage 2 of 2 stages. So why, let's look at the reasoning of the first stage, why there was a prima facie duty of care. Sorry?
A special relationship, they rely
Yeah, what was that relationship?
relationship between industry and the consumer.
No. We're talking about the government and the companies. So what was the relationship between the government of Canada and the companies?
Well, essentially, like how you mentioned, the federal government pretty much regulates the use of tobacco. It pretty much made that suggestion to them to reduce the nicotine, the grade of tobacco product.
Yeah. So paragraph 53, the court writes, Canada assumed the role of advisor to a finite number of manufacturers and that there were commercial relationships entered into between Canada and the companies based in part on the advice given to the companies by government officials. So here, if you remember Hadley Burn and then the adaptation from Hercules, we see special relationship, advice being given, and the question of whether or not it was reasonable, the implication being, well, the government is telling this industry, the manufacturers in this industry, that low tar, mild and light cigarettes are better for your health. And specifically about the reasonableness of the reliance, at paragraph 54, the court writes, with respect to the issue of reasonable reliance, Canada's regulatory powers over the manufacturers, coupled with its specific advice and its commercial involvement, could be seen as supporting a conclusion that reliance was reasonable in the pleaded circumstance. So the court, this is again all going to the idea, answering the question, is there a prima facie duty of care? Then the court becomes a bit more specific about what reasonably foreseeable means in this circumstance. And this is paragraph 57. And they write, all that is required is that it could have foreseen that its negligent misrepresentations would result in a harm of some sort to the tobacco companies. On the facts pleaded, it cannot be ruled out that the tobacco companies may succeed in proving that Canada foresaw that the tobacco industry would incur this type of penalty for selling a more hazardous product. So the court is saying, here we have, if we put in the language of Hercules, the reasonable foreseeability. Was it reasonably foreseeable that if the tobacco companies relied upon the government's advice and role, that they would incur a penalty for selling a hazardous product? The court is saying, we can't rule that out at this stage. We think it could be reasonably foreseeable. The reason why they say could is because they hadn't finished the analysis. But we're only dealing with that part one. Then they're talking about the reasonableness of the reliance. They say, well, certainly it was reasonable because of the role the government had. So this is why they say there's a prima facie duty of care. based on 1A and 1B, it looks like the government of Canada owes a duty of care. As we know from going through negligence, that's the most important aspect. It's probably the most difficult. So if you're the Canadian government, you're not very happy. Because it looks like you could owe a duty of care to the tobacco companies. But then we go to the policy stage of analysis. So again, looking at Hercules, defendants knew the identity of the plaintiffs, has to be used precisely for the purpose for which the information was prepared. Here they sort of have, because this is a post-Cooper case, they take sort of a wider view of the public policy and look at, is there any reason for us to negate recognizing a duty of care here? And as noted, when I started with the case, they say yes. And that is indeterminate liability. So they repeat what Chief Justice Cardozo said about indeterminate liability. And they write at paragraph 101, recognizing a duty of care for representations to the tobacco companies would effectively amount to a duty to consumers, since the quantum of damages owed to the companies in both cases would depend on the number of smokers and the number of cigarettes sold. This is a flow-through claim of negligent misrepresentation where the tobacco companies are passing along their potential liability to consumers and to the province of British Columbia. In my view, in both cases, these claims should fail because Canada was not in control of the extent of its potential liability. I don't know if that was a scream or I give up. But what does that mean?
Well, it means that notwithstanding the advice from Canadian government, it is a tobacco company that is manufacturing, selling and making volumes in the production and sales. It's Canada which is giving advice as to what might be more beneficial or more healthy.
Okay.
And basically they already knocked out, the court already excluded duty of care towards the consumers. So it would be a way around through the little or back door to get the consumers, again, able to sue directly the government.
So it might be useful to look at the consumer aspect. Why did the court knock out the consumer so early? Well, let's think through. Why would that be, that class, consumers, lead to indeterminate liability?
Well, everyone would sue. Not just the smokers, but the family, the deceased smokers, grandkids, like...
Well, that, but also, there is a condition, I think it's a condition, called secondhand smoke. So people that have worked at bars, for example, where smoking was allowed, but they never smoked, they also developed, let's say, respiratory lung issues related to smoking, not because they smoked, but because they were in the atmosphere of smokers. So the thinking here is, it wouldn't just be smokers, as Dayon said. It'd be their dependents and their family members. But what I'm adding in is, we could say, well, it's just that class of people, smokers and their dependents. And I'm saying it wouldn't be. What makes this indeterminate is that there doesn't seem to be really a limitation to who could sue, because you have this idea of secondhand smoke. It's not purely those people who use the product. It's anyone who was around people using the product. And that, how do you establish that?
What is the relationship between this indeterminate liability and proximity? Because there is not, This group of people that they might be potential plaintiffs, they are not in the proximity, like people would go to the,
But technically they are. The problem is that the proximity leads to almost everyone. Who's proximate to the tobacco companies? In this case, putting it another way, smokers. But we then see, well, it's not just smokers, it's their families. And then we see, well, it's not just their families, it's people affected by smoking who never smoked. So all those groups are proximate. And that leads to the indeterminate liability. Yeah.
So approximation is determined by an unbroken chain of connection.
Yeah.
So
What's the connection
It's
between
a
the
connection.
parties?
A causation, but it's for as long as you don't have any nose thing happening, intervenience or whatever is the name, there is a direct proximity.
Yeah, that makes a bit of causation language, but what might be easier to understand is just, there's,
Okay.
I lost my phone and found it.
good?
Is that the food, huh?
No, they took it, I don't know, the
There
other
you
side
go.
of York.
I'll go to garbage can.
So,
With proximity, we're looking at, well, remember what Lord Atkins said in Donahue and Stevenson, who's my neighbor? Who's the neighbor of a tobacco company? Simply put, smokers. But it's not just smokers, it'd be their families. But not just their families, those people who come in contact with smokers.
Forward,
Sorry?
forward.
Yeah, so when we're looking at proximity, we're looking at that connection that Lord Acton called a neighbor principle. How can we tie, who would be reasonably foreseeably tied to that? Yeah.
Have you seen some of the psychic shock or legal shock cases where the courts have limited the plaintiff, so to speak, in situations, in certain cases? Why couldn't the court have,
What do you mean, limited how?
well, in terms of saying, okay, people who watched individuals on the TV getting crushed by it,
Right.
that's too remote.
But that was the British courts.
That's right.
We haven't found, the Canadian courts, not, as far as I know, have not pronounced on that.
Okay.
So the British courts, that was the Alcock case, and then there was White within the span of a decade, and the House of Lords was concerned about psychiatric damage being extended too far. So they took what was basically a very blunt approach. If you, this was within the context of the football stands and the people being crushed. You may have had a relative that died there. And you may have thought you saw them on TV. But you were not close enough to the activity to be within the zone of a duty of care. If they were there and saw it, then they could have recovered. But seen on TV was not close enough. And then there were further issues with Alcock, like how close of a connection must there be? And they got into some really strange statements about things. Like maybe brothers didn't like each other, or maybe husband and wife didn't like each other after all. So they can't say she's happy. Yeah, something like that.
So why couldn't the Supreme Court of Canada said, look, we'll limit the persons within the sphere of the proximity to users?
In the tobacco
Yeah,
case.
why not? Why couldn't you say something like that? Because let's face facts, it's logical that consumers of the product are going to be the front line.
Yeah, but they aren't the only ones suffering a loss or harm. And I think that would have been a hard line to draw. I don't know all the submissions that were made in this case, but if I were putting it forward and saying, I don't want it limited to that group, I'd have studies that should talk about the knock-on effects, what I'll call the knock-on effects, like secondhand smoke. And you couldn't limit it only to people who were consumers of the product.
And I guess you could argue even worse versus the second ones then.
Yeah, because they didn't even choose to engage in it. So, you know, we could take a cynical point of view too, which I think some people have with this case, to say basically, the Supreme Court saved the federal government.
That is true, because the feds are taking taxes, they're taking a cut out of the profits so heavily that they're rolling in mud like pigs. Everyone is happy.
You paint a picture.
Yeah, tobacco companies are making profit, but when they want to say, well, listen, if you're on the hook, you have to return something back, but when it comes to our government, that never happens. Our government basically is just the saint. So whatever they take, they never return back.
Okay. So there is that line, what I'll call sort of a cynical line, and I don't mean any judgment for that classification. But I think there is something to that, to say, well, you know, thank God for the Supreme Court, if you're the federal government. I can understand, though, the indeterminate liability point, and that's why I focused on it. Because even if there is some merit to the cynical point of view, I don't want you to come away from this thinking that cynical arguments work every time. There is something that grounds the decision, I would suggest. That grounds the idea of indeterminate liability that I've just talked about. Who are the people who are harmed? We can't really close off that group. We can't make it a defined group.
So, like, when I compare the facts, like between this case and Maple Leaf case,
Right.
it's pretty similar, like, because
No, really? No.
because in that case, like, there was a franchisor, so that's something to do by franchisee, and there was the case was like, is the franchisor was due to
But it wasn't the franchisor.
consumers,
No.
or the Maple Leaf, no, not
It was
the Maple Leaf.
the Maple Leaf Foods.
Yeah.
Did they owe a duty of care to the franchisees?
Yes, in that case, so the court said no, because the issue of the proximity, so Maple Leaf doesn't like owe a duty of care to consumers because of this proximity. But here, like, it's a kind of, in my mind, I see the two cases are like pretty much similar, because like government of Canada, like directly it's like relationship with the producers of tobacco, and at the next step there are the consumers. In both cases we cannot like really determine exactly which are the potential plaintiffs in both cases. But in that case, like the Maple Leaf case, the court, like the rationale of the court was about the proximity part of
And
the
the
issue. But
reasonable
here-
foreseeability.
Yes, but here it says like indeterminate liability, but I see both of them like quite similar.
Well, okay, let me show how they are. And Maple Leaf Foods was a defined group of people. Sorry?
Consumers, they said
No,
that the
it was not consumers. It was franchisees only. Maple Leaf Foods was implicated in the news with contaminated meat.
Yes.
None of that meat went to Mr. Submarine franchises.
Yes.
No consumers were harmed. It was only the franchisees who were suing Maple Leaf Foods because they were saying, because you're in the news with tainted meat, we're losing money, everybody's going to Subway. And we want our money back. So it had nothing to do with consumers. It was a defined group, only franchisees of Mr. Submarine Whereas in Imperial Tobacco, we do not have such a defined group. And even if we did define them, I would say the numbers are just so exorbitant. So that's one difference between the two. Do you want me to go on? Sorry?
No product ever sold to the consumer, you said.
Yeah. So with Imperial Tobacco, we have a very different relationship in the facts. Caroline started with the initial litigation. This all started because the BC government sued the tobacco companies and said, you guys suck. We have all these people who are ill and dying from tobacco-related illnesses, and we want you to pay. And the tobacco companies said, we only did this because the federal government told us it was okay. So who you're really suing is the federal government. And they dragged them in to this. We don't have that here. We don't have a relationship where one party, a government body for that matter, is advising the industry regarding the harm level of products they're selling, which already I would think they acknowledge were hazardous to begin with. We were talking about different levels of hazard. The contaminated meat case, there was no contaminated meat that actually got to anyone. So there is nothing there. We didn't have people in hospital or anything like that. So there are some significant differences within that. Constantine.
Then the tobacco company, didn't they also forward the same argument against the customers that the indeterminacy of the damages? Wouldn't they say when the customers sue the company that the numbers are?
Yeah.
Because the reasoning is the same, like it can be applied in both situations.
But you made the problem.
Yes, but
And the government didn't force you to make tobacco. Like, I think that's
was
it.
it based on this misrepresentation or
Well, the tobacco companies were saying, you told us this was okay. Mild and light cigarettes were okay to sell. So you were negligent because they're saying, maybe you took due care, but it wasn't sufficient.
Yes, but
So you misrepresented to us that we would not be in a bad position at some later date where consumers are suing us.
Yes, but when we have these actions of consumers against the company, we
Yeah.
can say the numbers are, we cannot control the number because we have the smokers and then family and then sick. Then
Yeah.
they say the same argument, that
But-
we cannot control the amount of losses.
I guess the thing would be, think of another example, like Chernobyl. You know, you could, well, hell, we just decimated a town. That's too many people. Well, you did it. You can't use the grandeur of your harm as a defense. So if you did something that harmed so many people, I think there's more of a directness with the tobacco manufacturer and
Yes, but
those harms.
we could say that the company also wants to have profit, and we expect that the company may not warn about the dangers, but when the government does not do that, it abandons and basically...
Yeah, well, I don't know what the Chernobyl litigation was about. I didn't even watch the miniseries. I think I'm the only
No,
one.
I'm saying about the company, we expect
No,
that...
I know,
yeah.
but what I'm saying is, it's harder, if we take the government thing out of it, I was just using the nuclear disaster as a comparator. If you're the author of all the harm, you can't say, I harmed too many people for them to sue me. That's not, like that's essentially what we're leading to with the tobacco companies. there were just too many smokers. And then they had kids.
It's not,
Those silly bastards.
the reasoning goes like that, if we accept this kind of.
No, but there's a key difference here. Like, Canada is not, the government is not telling them, make this product. And like, it's once removed, at least, from this whole thing. Who created the harmful item? The tobacco companies.
But the problem is not the creation, because we have still tobacco companies
Sorry?
who create the cigarettes. The problem is that people were not warned about it. So my question, that they didn't know about the dangers back then, about the health risks.
No, they didn't know. That was part of why we have these facts.
The consumers.
Yeah, because the idea was
No, but the light cigarette.
you won't be as harmed if you smoke a light or a mild cigarette. So they were knowledgeable about what happens when you smoke cigarettes.
Yes, okay. But who has the obligation to inform the people, the citizens of the country about the public health issues? Would you say it's more,
Yeah,
Yes.
but
like when I want to know.
But that's
about-
presuming that they didn't. It's not, I would say, it's not like Canada put up signs on TV saying, don't smoke regular cigarettes, these light ones are better. Yeah, they didn't do that. The tobacco companies are saying, you misled us. You made us think that if we sold light and mild cigarettes, people wouldn't sue us. And that's not what really has transpired. Yeah.
That's my idea, because I said that you taking a different approach, not.
Who's they, sorry?
The Supreme Court, taking a different approach and having no proximity between government and the customers. Then the tobacco company would be responsible. This way the tobaccos, because unless it indeterminate liability, it gets them out of the hook. Because in a way, they are putting it to the federal government, and the federal government has this indeterminate.
But I think the problem the Supreme Court had was that first stage of the analysis led to the government being liable, the prima facie duty of care. But their reasoning sort of reinforces why we have the two stages, sort of the legal analysis and then the public policy. Because sometimes there are considerations that go beyond just the strict legal that come into play.
And that's the biggest problem.
What do you mean, sorry?
Well, public policy, it's a wild card. It can be pulled out at any given time, and
Sure.
there is no expectation. You can be completely blindfolded how any argument or fact will be
I would
perceived.
say that the lawyers for the tobacco companies were probably very well informed that this was a problem. I don't think anybody who goes to the Supreme Court in this topic is unaware of the indeterminate liability argument. So there wouldn't be blindsiding there. Sorry, you had your hand up earlier.
Yeah, actually, I have some problem with this analysis of indeterminacy, because if we substitute any other private entities for the government, and let's say that there's a tobacco grower who sell the tobacco leaf to the tobacco company, and when the leaf turns out to be contaminated or is bad quality, then actually the tobacco company cannot win a case against the tobacco grower, because the same concern indeterminate liability. Because
I don't
there are
understand
a lot of smokers behind the tobacco companies. So whenever the tobacco company win any case against any maybe
I don't think it would work that way. Let's take the Maple Leaf Foods scenario as a comparable. If Maple Leaf Foods sold contaminated meat, it wouldn't be a matter of indeterminate liability. You'd have 10 people in the hospital throwing up Maple Leaf Food.
But actually, you cannot foresee that how many people would be the case in the future, maybe in the next 3 months or
But
so?
it wouldn't be, you couldn't have an indeterminate liability matter like that.
I mean, because
With the, like contaminated food as an example.
yeah, means because there's a difference between tobacco and the meat, because meat has
Yeah,
a
but
very short
if,
duration.
but I would say that Maple Leaf Foods supplying the meat would be like your tobacco grower.
But if we put to the extreme said that maybe
Sorry?
provide, I mean, put to the extreme said that provide the
There's no help
contaminated
in
meat
extreme.
for several years, and there is long-term concern that you will develop
People been
long-term.
eating contaminated food
Yeah,
for
for
several years.
maybe 50 years, and maybe they say that this will be cancerous, maybe medical search.
I would suggest we're not living in
I
Canada.
just put to the extreme to show that it could be problem in the
Okay, possibly, but I think that's, as we say in Torrent, far too remote. So your tobacco grower example, I don't think would work because the contaminated leaves that was sold on, they could say, well, look, all these people are sick, we've traced it back to you, you owe us this. So it wouldn't be indeterminate. And I don't want to live in the country you have in mind.
It's just it's a made up news that to put to the extreme to show that the reasoning could be.
No, I understand, but I don't think that would be plausible, honestly. The facts requiring people having to continually eat contaminated food. I'm thinking of McDonald's workers. If they had to dine on McDonald's only, maybe, but that's the closest. Yeah.
Well, he's got a point, because the World Health
Don't do
Organization.
that.
The World Health Organization just labeled cured meats as the #1 carcinogen on equal par with cigarettes.
Okay. And?
So technically, if we all consume cured meats. we're-
Yeah, but the WHO did not say.
There's no labels on this product.
No, but I think what they're saying is, eat processed ham every day for a year, maybe you'll have problems. But nobody does that, I hope.
No, I think processed meat is classified as dangerous as a cigarette. Let's say if you smoke one cigarette every day, maybe you don't have big risk for cancer, but if you smoke one packet, you have more. But it's the same risk.
What about GMO? What about GMO? Basically, they're getting to the point that the government is not informing us about any health risk. Not only not informing, basically stopping us knowing, because it's not even, they don't even have to put on the labels that it's a genetically modified product.
Before we
They don't have to.
get down
They don't
too
even know
many,
anything.
if I could just, before the break, before we get down too many conspiracies.
No, I don't think.
No,
I think the
but
government is not providing.
maybe, but we had this discussion, I think, before. Sometimes when information comes forward, there's a testing period of things. And maybe we're at the beginning of an end of processed meats, maybe, but it hasn't got to that point yet. Like cigarettes, when people were saying, I keep getting sick from cigarettes, then there was testing and so on. Not,
No, it's also profits.
Yeah, profit.
The profit,
It's not,
that's
it's
the
all about
problem.
it.
sure.
Genetically
I
modified
was about
products
to
are
say,
not
I'm not
allowed
taking
in
away from
Europe.
that.
Why?
Because this,
They don't have.
like applying to processed meats in area, if we apply the technology to the processed meats in area, the processed meat companies, as long as they're controlling the regulations that have, they will go with it, indeterminate liability.
Yeah, but I say it's different because by the time Imperial Tobacco became a case, we knew about the serious health risks about smoking, no matter what. And a contemporary example now, I would say is vaping. Where now it seems one of the states in the US has noted a lot of illnesses potentially being attributable to vaping. Yeah, so they have to test that, there has to be science behind it, and so on. But in the meantime, arguably, people are getting ill. But it's not because they're putting money or profit necessarily before it. There has to be solid science behind it, like we had with tobacco. It is the point here. So I'm not going to have any more sunlight. No, I don't need sunlight anymore. We'll take a break, 8:40, come back at, 7:40, come back at 8. And the attendance is sunlight.
Sorry about this. We had left them outside 35.
But there are two issues relating to comfort letter issued by Deloitte with respect to solicitation, and then there is the audit.
Investors.
So it's investment solicitation, right? And the second issue was the examination of the statutory, during the course of a statutory audit, irregularities were found equivalent to fraud that were discovered and not revealed to management or to the directors, but they compromised their position and issued a clean audit report subsequently. Both of those issues were dealt with separately in the lower court. Both issues were treated as representing breach of duty of care, and they were held to be liable to Deloitte Touche in the quantum of $84 million.
And the Court of Appeal upheld that.
Right, and the Court of Appeal upheld it.
Ontario Court of Appeal.
Then it went to the Supreme Court, and the Supreme Court had a split decision with the majority going for a amended decision whereby they did not see the see Deloitte as being liable for the purposes of advice comfort letter given for the purposes of the solicitation of investment, on just the premise that purely on the basis that the advice was not given to the company, but was given to potential investors. So, in other words, liability lies not to the company, but to the potential investors, and the potential investors were not the litigants. On the other hand, when it concerns the statutory audit, the court found that there was a duty to advise or to inform management of irregularities, so not management, shareholders, so they can take administrative actions to prevent further decay in the financial position.
So Livent was a big company in Canada that put on basically all the theatrical productions in Toronto. And the head of Livent went to jail. For his role in a number of things. So this was a big case, big event in terms of corporate Canada. And I think I would say that this case also it comes out of what happened in the Great Recession. So I did my doctorate at the London School of Economics, and the Queen opened a new building there, and I was there. And she's famous for saying at that opening to economists, "Why didn't you see this coming?" Which is actually quite a profound question. You know, if you're an economist, why didn't you see the Great Recession coming? And so I mentioned this as a way to sort of bring it to the day-to-day life. Coming out of the Great Recession, I think there is a lot of skepticism about accounting firms, auditors, and so on. And I think this litigation, it would come out anyway, this litigation, but I think the backdrop is that. what were accounting firms doing during the Great Recession? And before, we had scandals before that. So you have people saying, you, Deloitte and Touche, were part of the problem. And you are, under statute, meant to be a check on the work of the officers of the company and directors. And the allegation is you failed this. So in terms of negligent misrepresentation, what is being said here? Well, Tamesh mentioned two instances, and I'll name them, the August 1997 and September 1997 events. August 1997 are the events around the irregularities. And the court says you identified irregularities in the reporting of profit from an asset sale, but you didn't resign. You took this next step, which was September 1997, where you helped Livent solicit further investment. And you helped them to prepare and approve a press release for that purpose, which misrepresented the basis for the reporting of the profit. So you identified an irregularity from an asset sale, but then in August, but then September, you helped draft a release to the general public for the purpose of soliciting an investment that said basically things were okay. So if you were the plaintiffs, and who are the plaintiffs here?
The company itself. Shareholder. Sorry, not the corporation is the plaintiff.
Sorry?
The corporation. But it's the shareholders, hold on a minute, it's the company like that. Inc.
It must be the receiver, because the manager who was appointed during the bankruptcy, because he kind of probably thought that this was the source for getting some money for the company.
Well, Livent had debts. And so the receiver, who's appointed in bankruptcy, has to take over the company. So the receiver is saying there has to be more money. And we say it comes from you, Deloitte. So it's important to identify who the plaintiff is, because it makes a difference as to what the decision is saying. Sorry? Caesar?
No, I'm just wondering what's the question.
No, what you said, the receiver is the plaintiff.
But the receiver acting on behalf of the company.
The company, yeah. So the articulation of this is important. It's not the company itself, right? Because you say, well, they must have known. It's the receiver who comes in after all the messy stuff has happened and Livent is bankrupt or in bankruptcy proceedings. And a receiver is appointed by the court to oversee what happens with the remaining assets to pay out to the debtors. So what were they responsible for, Deloitte? If you look at paragraphs 2 and 3, paragraph 3, they write, "We conclude, however, that Deloitte should be liable for the increase in Livent's liquidation deficit which followed the statutory audit." What does that mean?
Well, I think that statutory audit showed more money than actually existed. They
And-
reported the, assets to be higher than they should be.
And what's Deloitte's role in that?
Well, Deloitte and Touche was also one of the largest accounting firms in Canada.
Yeah.
Like big wigs
Yeah,
when it comes to that, same as Livent. I mean, they had a reputation and the name, and whenever they got involved in working for the company, they were by itself a substantial way to give a credibility
yeah.
to the company.
So when you have a big accounting firm like this, you're buying its reputation, and the weight of that reputation behind it says, this is good.
they're standing behind, we did it, so it looks like,
Yeah,
okay job, but basically they failed. And when they discovered that there is a irregularity, they were actually duped, but they never went into it. They didn't resign, so they actually continued portraying that they're standing behind the company
yeah.
as a big accounting firm.
So the misrepresentation of what the company had, Livent had at that time, following the statutory audit, they are liable for. What are they not liable for? And this is where we differ. We find a distinction between the Supreme Court and the two lower courts. What is Deloitte not liable for? So it says that, yeah, Constantine.
You're not liable for potential investors, let's say, who rely on this audit, but they are liable to shareholders who couldn't exercise properly the right of supervision of the management of the company. So,
Okay.
because this was the purpose of this audit.
Yeah. So paragraph 2, Deloitte and Touche should not be liable for its corporate client negligent, corporate client Livent's increase in liquidation deficit which followed Deloitte's provision of negligent services in relation to the solicitation of investment. What is that referring to? Sorry? Yeah, it's referencing third parties.
So basically just trading losses.
To some extent, it's referring to that September 1997 event.
Yeah, when they provided, they helped with the press release.
Yeah, so I'll just read the facts. Deloitte, instead, for the purpose of helping Livent to solicit investment, Deloitte helped prepare and approve a press release issued in September 1997, which misrepresented the basis for the reporting of the profit. And this press release was for the purpose of soliciting further investment. So the Supreme Court says Deloitte was not liable for that, but it was liable for the liquidation deficit, the difference, following its statutory audit, the August 1997 event. What's the difference here?
The purpose of its transaction. The first letter, the purpose of it is we're going to enable investors to trust the situation of the company and increase investment in the company, whereas the second, the audit, the purpose was to allow shareholders to collectively supervise the management.
Okay.
And because it was not properly prepared, that's why they were not able to discharge their.
So the key word is purpose. Remember, we looked at Caparo versus Dickman. Do you remember those facts? Caparo is a shareholder of Company X. They get an audit from Dickman that says the company is in good financial health. Based upon Dickman's audit, Caparo purchases Company X, finds out that Company X is not as valuable as Dickman said, and sued Dickman. And the House of Lords found that Dickman owed a duty of care to Caparo as a shareholder, but not as a potential purchaser. The key word there was purpose. What was the purpose for which Dickman was engaged? The purpose was to provide an audit, not to provide a valuation of a company for the purposes of potentially purchasing it. The House of Lords distinguished the purposes, and on the premise that in tort, especially negligent misrepresentation, you cannot be held liable for a purpose that exceeds the purpose for which you were engaged. And if you recall, when we talked about Caparo, I talked about how law firms will provide their assessment of a recent appellate level decision. And I used the example of if Caparo went the other way, that would mean that people reading these assessments on a law firm's website and acting on them could sue the law firm, because the purpose didn't matter. They just gave this advice and anybody could act on it. I suggest the Supreme Court is doing the same thing here. There are two purposes at issue here. One is the purpose for which Deloitte was hired, the audit. The second is helping Livent to solicit further investment. And the Supreme Court says the latter one that I mentioned, soliciting further investment, is not a purpose for which they were engaged. Therefore, they are not liable. I'll discuss that a bit more, but at this point, is that clear? Now, I think there's a problem with this case. The problem, I would say, is this. Deloitte wants to do well by its client. And goes above and beyond the auditing to help solicit further investment. But it voluntarily and willingly does so. So it engages in crafting this press release designed to solicit further investment and is indeed successful in soliciting further investment. My contention is the purpose argument or distinction that the Supreme Court employs not blurred, at least if not done away with, when put in tort language. It seems as though Deloitte has assumed responsibility. If not assumed responsibility, at least willingly acted in this endeavor. And going to Dayon's point, putting the weight of their name behind this press release for the purpose of soliciting investment to help this client.
I have a little disagreement with that proposition.
Yep.
To start with, the press release and the comfort letter, well, at least the press release, is not issued by Deloitte. was issued by the corporation. It's their press release to the public.
Right.
And their advisors that are behind that press release.
Right.
So the stage is a step away from the actual purpose or behind the purpose. Compared to a statutory audit, which is Deloitte's audit. So one has to take that into consideration. So the press release have a different purpose.
Yeah.
And that's the distinction that the court is making, and I'm following that distinction.
Yeah, but what I would suggest is, when you go to law firms today, law firms do not exclusively work in law. They have a consulting wing. And they do consulting work for their clients. Does this mean that when a firm, accounting or law, engages in consulting work beyond the remit of what they're known for, accounting or law, that is then beyond the purpose for which they were engaged? Following in with this case, so that they would not be liable for their role in this. So while Livent submitted the press release, it was in their letterhead and name, Deloitte was there in name, Deloitte helped write it. So there is more than just, what's a good example? When Trump bought Mar-a-Lago, his place in Florida, he would make up all this crazy stuff. Like he'd say, Prince Charles is looking at buying a place here. Or, Princess Diana is a member. Well, technically, Princess Diana was a member because he gave her a free membership. So you can massage words in a certain way, but that doesn't change the underlying principle, I suggest. So here, Deloitte was actively involved in this. And that's what I'm looking at. You can still, we may disagree ultimately on it, but my point is, I think it's a bit more problematic when you willingly go outside of your area to help a client, and the court says, well, you can't be responsible for that. Because I think that there's, put very loosely, and this isn't a legal argument, there is a morality point that I'm making here. Deloitte willfully wandered into this territory and is benefiting from a distinction that's made in law. But arguably, they still engage in something wrongful. Nonetheless, are benefiting. And I think that may explain why we have the distinction between the trial and appellate level of the court, Ontario courts, and the Supreme Court, where the Supreme Court is saying, we're applying the law, and maybe the lower courts felt there was something more going on. Yeah.
Just perhaps a fly in the ointment here is to do with the fact that the company was fully cognizant of the irregularities, and they were discussed at various times.
Yeah.
And Deloitte relented towards the end when they issued the clean audit report and also the premise for the press release.
Yeah.
So to me, that must have factored into it, that you're suing me now, when you yourself, the company, was fully cognizant of the irregularities.
But that's why I said
released.
It's important to keep in mind who the plaintiff is. Because it's the receiver in the place of the company. So it's a bit harder, I think, to make that distinction, to make that point. Although I understand what you're saying. Another way of putting it, though, I think is, with the Deloitte example, if your client Livent is not owning up to the irregularities, what do? Let's take a criminal law example. Your client, so you've all heard of the Paul Bernardo case? So he told his lawyer, I videotaped everything. they're in the lights. Go get them. Somehow the police missed it. I don't know how. But his lawyer gets the tapes, looks at them, they're bad. Isn't that when you resign? When your client is ignoring you or asking you to participate in something that is wrongful, as a professional, is resignation not the only step to take? And I point that out because Deloitte didn't get an answer, but still went on. So Livent knew about these irregularities, carried on, but so did Deloitte. Deloitte made a business decision. I understand the business decision, and maybe we all would make that same decision. But in this context, I would say, from a professional responsibility perspective, resignation should have been the option there. But surely it shouldn't have been, okay, let's look at the press release. Not to participate further in things. So that's why I have the difficulty with this decision. I understand the purposes. Maybe the Supreme Court was concerned about blurring that distinction. But I think when we get to looking at the conduct of Deloitte, I think that in itself is a bit problematic. In terms of the tort question, I don't know, but I'm sure there would have been a professional responsibility case against them. They would have been reported in some way. All that is aside, though. In terms of the tort, the negligent misrepresentation, maybe they're not responsible for all of it, but maybe there's a contributory aspect. And we would say contributory, but not joint and several. Because joint and several will mean you sue Deloitte for everything, and they have to pay everything. Livent is bankrupt. So that's why I say maybe contributory negligence where you apportion responsibility. But I'm troubled by the decision for that reason. I put that out not as a final word, because
Who ultimately managed the money?
Sorry?
Well, they participated, I understand, in the fundraising, the press release, but ultimately, who managed the money that was received from that fundraising?
I wouldn't say, I don't know for sure, but just generally speaking, whenever a company engages an accounting firm, I would think both of them do.
Okay. So, but if we're talking about the mismanagement of the funds and the money, who ultimately is responsible? Isn't that something that the court probably looked at as well? In my accounting, if I get audited, like the CRA, yes, my accountant's involved in this, my books, but ultimately I bear the burden.
Yeah, but
How negligent he is. Jumps over the arm.
yeah, but I would say that if he helped you, which I'm suggesting, this wasn't benign. Deloitte participated. In tort law, we'd say they took the positive act. Remember, we talked about affirmative action where you don't have to do anything. They did something. And I say that's different from, in your scenario, you do something wrong and your accountant misses it or whatever. This is different.
There is not a plaintiff, let's say if you sign a third party,
Yeah.
start with a claim. And they'll
Well, the people who invested
Right.
as a result of this.
Correct. They'll join Deloitte. Then the court will think that this is consideration, and will treat it like did Deloitte also do the care to this other people.
That's an open question, yeah.
Yes, but the court, there were no plaintiffs, so the court could not, they could have done it in arbiter, but that wasn't the question which was posed before the court.
Yeah,
So the receiver, at the end of the day, all he cared is the money owed to the shareholders and or to the company, not to whoever else would have had to pay.
Yeah, and maybe in the future, that factual point prevents this from being a precedent. In my example, where the accounting firm does some extra work that's beyond accounting and tries to escape liability on this case. Maybe. Valcard,
I was going to say, as mentioned, like from an ethical perspective, like coming back to professional responsibility, it reminds me of that one section of the model code where it says that the legal advocate, like if you're knowingly, if you know that your client is partaking in some form of criminal activity, or in this case, like fraudulent activity, clearly obviously you shouldn't engage in a debt fund, and also there's like steps, like procedures that you should follow, right? So obviously bringing the attention to like the board of directors first, and kind of going up the hierarchy,
Yeah.
and where everything was failed, then you should resign, and that's the most ethical thing to do in that situation.
Yeah, I just question them continuing on. I think there's something more to be said on that level. Maybe ultimately they're not liable. But if we're looking at precedents, this is an important decision in negligent misrepresentation. And I would say this decision came as a surprise to many people. I think most people felt Livent was done at the Supreme Court level. And we're surprised that the Supreme Court made this distinction because the trial and then the Ontario Court of Appeal found them responsible on both points.
Just to a final point from my point of view. The investment debtors, who misrepresented to them? It's not Deloitte Touche. It's the company management that misrepresented to them. And therefore, the proximity of their claim rests with the company.
Sure.
And this is the distinction that the Supreme Court was making between the statutory audit and the consultancy engagement.
Yeah.
And so
But it's
sometimes,
not that
we
fine.
can get a little emotive about wrongdoing and about morality. But the issue here, and when you compare that issue with who really is the debtor, shareholder, who made the direct misrepresentation was made by the auditor, from the audit report.
Yeah.
So one has to look at the proximity of the
I
claim.
understand that. And my point, just to underline it, is that that gives the impression that it's all Livent. And I'm saying Deloitte had a role in this. And that's where I question things. Maybe the decision is right. And I am looking at what precedent this can be. But as Bartek mentioned, maybe the distinction, my concern over the precedent is that, well, factually, the parties that could have claimed against Deloitte were not parties.
Well, it's not really like that. The company, Livent, was in receivership, which means whatever assets were brought back to Livent would be a part of the obligations that Livent has towards third parties. And shareholders. So it wasn't just about shareholders sharing any remaining assets, it was also protection of third parties that lost based on investment that was bogus from the get-go.
I think given the Livent status of insolvency, so any proceeds from the litigation most likely go to creditors, so shareholders will have nothing. But the question I have is why shareholders did not sue Deloitte directly, because they have reason to rely on the comfort letter because it's a public offering of debentures.
I don't know.
If I may just add one thing, it is really awkward that Deloitte was doing the statutory audit for shareholders of the company, and then was working as a consultant.
Yeah.
That's a clear conflict, like it's a red light for from the beginning.
Yeah.
No, but
Like,
that's not how it works. I work for Deloitte myself. I'm KPMG. Normally, there are clear distinction between the consultancy department and the statutory audit department. And although some of it is blurred, that distinction has to be maintained. That's by ethics and by
What's the
functionality of the
term? Have you
company.
been told the term?
Chinese wall.
Yeah, I was hoping there was a
wall, yeah.
politically correct.
But, and in fact, they're set up with separate leading partners and managers in each section.
I agree, but the name is the same.
Yeah, and
It's not
they even have law firms within Deloitte.
Yeah,
That carries
so
out
you
law
will
and
find this in
insolvency
law
work.
firms too, where, a partner has joined the opposing counsel firm, and they have to set up this wall between them. I'm not, both points I think coexist, is my point. The last thing.
Oh, I was going to say, the bright line rule, right? That it?
Yeah. So relational economic laws. I'm skipping a few topics because this is one that I think is important to understand. And simply put, you couldn't recover for relational economic loss. Because, well, the definition loss that flows on because a third party has contract to use something that has been damaged by the negligence of the defendant. So, look at Spartan Steel versus Martin, 1973. And Lord Denning makes one of his final appearances for us. And this case is a bit complicated, but illustrates relational economic laws. So I'm going to oversimplify the facts. Spartan Steel obviously makes steel. Martin is doing some sort of construction in the area and somehow cuts the power to the whole area. Therefore, Spartan Steel has a problem. They can't make steel. But Martin, you don't have this connection between the two necessarily. What you have is, so Martin didn't necessarily directly interfere with Spartan Steel's business. It was sort of indirect. And because of this, there's this gap that's hard to bridge. And the gap is expressed this way. Let's say Spartan Steel can make 4 bars of steel per hour. And the power was cut at about the half-hour point. So 1 bar is made, 1 is being made, 2 more to come. If you're Spartan Steel, you want to recover for all of that. Let's say the power goes back on the next hour, just for simplicity. So it's only that 1 hour. The law is Spartan Steel cannot recover for all 4. They can only get, so the first one was done, so it's okay, but the second one they can recover damages for because it's not as good a quality of steel. It hasn't been finished because of Martin's negligence. But the other 2 melts, bars of steel, that they could have made in the hour that Spartan Steel cannot recover for. So it's only loss that is related to physical damage that can be recovered.
Because they can make later.
Yeah, or...
So basically the time was lost is
But-
not covered.
No, the time isn't lost. It isn't recovered.
That's what they lost. return.
Yeah, but they can't recover for that. They can only recover for the second bar that wasn't as good a quality. So the difference in the price.
From what I recall, wasn't also because the court stipulated that because power outages is something that's foreseeable, that Spartan Steel should have taken the initiative of meeting a backup generator as well?
Yeah. But just for keeping it simple, I'm doing it this way. So you can only recover for relational damage. But then we have Canadian National Railway. The Canadian National Railway asks, what if somebody damages a bridge? For example, they run their tugboat into the bridge and damage it. And trains can't pass. Can CN sue the tugboat? Canadian National Railway versus Norsk Pacific. Can CN sue the tugboat and recover for what they lost by not being able to use the bridge? And the Supreme Court says, yes. They say, so they get around this whole thing about, well, if we apply Spartan Steel, it could only be the train running across at the moment. But it's all traffic that's been affected by the bridge being out of commission until it's repaired. So the future bars of steel. And the Supreme Court says you can recover here the relational economic loss. So in Canada, Canadian National Railway seems to be a more liberal interpretation of relational economic loss. You don't have to necessarily have the damage to property at that moment. It could be damage to property that affects future economic loss, which is different from Spartan Steel. And Bow Valley is a hopeless case, so we're just going to pass over it. And we'll pick up on Wednesday with contract and misrepresentation. Bow Valley, I've tried reading different textbooks. Nobody really seems to know exactly what the court is doing. That's not the only one. There's a breach of confidence case. Black Minerals. Black Minerals is the most hopeless decision I ever read. Just crazy. It's about breach of confidence. You might see it when you look at your privacy essay. Oh, and on Wednesday, if you have questions about that.